When you are charged with a criminal offence, the onus or the responsibility falls on the prosecution to prove beyond a reasonable doubt that you are guilty. You don't have to prove your innocence. However, when you have a defence, the onus or the responsibility then flips onto you to provide that evidence of the defence. I recently had a very successful result in the magistrate's court where I had very serious charges withdrawn on behalf of a client who, when he was driving his motor vehicle, had an epileptic seizure. Lost control of his motor vehicle, smashed into a couple of cars, ran through a red light, narrowly missing and miraculously missing several motor vehicles, and then crashed into a commercial building through a window. Thankfully, no one was hurt, otherwise he would have been facing much more serious charges. But he was charged with reckless conduct, endangering serious injury and dangerous driving, a host of serious charges where he could have been looking at some sort of jail time and lengthy license suspensions. Now, because the medical evidence that we provided did show that he was encountering an epileptic seizure, he was not in control and could not have willingly engaged in any dangerous or reckless conduct. Therefore, the police could not prove that there was any willing or intentional or reckless behavior, and then withdrew the charges that were applicable. It's very important that you understand that a defense needs to be supported by solid evidence if the police are going to consider withdrawing any charges, or if the magistrate is going to entertain that defense when considering a verdict and considering whether you are not guilty of an offense. If you do want to consider a certain defense and you need to run it by a lawyer, run it by Marcellus Law, I will let you know whether you have a leg to stand on, whether the evidence is compelling enough.